Thank you. Thanks for coming. Nice to see you. My name is Natalie Mera. I'm the Executive Director of the Ontario Health Coalition. We're here today about Bill 7, which is euphemistically titled the More Beds, Better Care Act. It actually does neither thing. It's a bill that actually was created by the Ford government, passed at the end of August, and its final set of regulations came into effect yesterday. And what the bill does is that it allows hospitals or discharge planners to override the patient's right to consent, to do an assessment of a patient without their consent who is waiting for a long-term care home bed in hospital. They can assess the patient without their consent. They can fill in their application paperwork without their consent. They can share their personal health information with a whole array of long-term care companies, for-profit, not-for-profit, and other healthcare provider companies without their consent. And then they can admit them into a long-term care home or other service without their consent. If they don't go, and the distances are set in regulation up to 70 kilometers away in southern Ontario, the regulation stipulates up to 150 kilometers away in northern Ontario, but if they don't have a bed within 150 kilometers, it can be any distance in northern Ontario in the regulations. So that 150 kilometers is kind of propaganda, but meaningless. And if they don't go, the patient can be charged $400 a day for their bed. So that's the stick. That was what came into effect yesterday. And as of yesterday, patients in Ontario who don't go to a long-term care home that is not of their choosing, that they don't want to go to, can now be charged $400 a day in hospital as a coercive measure to try to force them out into the long-term care homes. This, in our view, is a really hideous piece of legislation. Obviously, we have a crisis in our hospitals. We have been, we have advocated for decades now to improve hospital capacity. That crisis in our hospitals is a crisis that is the making of policymakers. It's the making of this government and previous governments by choice to not fund our hospitals, to cut hospital beds in Ontario to the lowest level in the country. I mean, we're not within normal range. We have the fewest hospital beds left of any province in Canada. Canada as a whole is near the bottom of the entire OECD. We are a radical outlier among nations in terms of how many hospital beds we have left. We fund our hospitals at the lowest rate in the country. And so anyone saying more funding won't make a difference is, it's completely false. And so the burden of this policy to deliberately downsize and privatize hospital services, because everything that has been cut from hospitals has been privatized, is now being borne by the frail elderly. That is not acceptable. It would not be acceptable to say we take this one patient group and say that their lives are less worthy than others, that we can put them at risk of death or set them on a path to death, where we won't do that to others. That's acceptable for anyone. It is not acceptable for the frail elderly. I'll just run through a few questions that a lot of people have been asking us about this. We're launching the Charter Challenge today because our members have asked us to, because regular Ontarians have put enormous pressure on us to find out what we could do to actually fight this. There is no appeal in the legislation, so people who don't want to go to the home that is not of their choosing or that they're afraid to go to because it has terrible care have no recourse here. They have to go, or they'll be charged these really whopping penalties of $400 a day. The only recourse that we have now is to bring a charter challenge. And so today we're launching that. We're asking Ontarians who care about this to help fund it. It's going to cost us a lot of money. We're going to need about 1,000 people who are willing to give $500 each, or 500 people who will give $1,000 each, or in that range in order to fund it. We will do it regardless, and on principle, we have to do this. In answer to people's questions, yes, this kicks in immediately. No, there is no ability to appeal. Yes, they can force people into homes that are in COVID outbreak. They've now allowed admissions into homes in COVID outbreak. Yes, they can force someone far away from their loved ones when their loved ones are not able to visit. That is what the legislation is designed to do. It's designed to clear out the beds. Are there other options? Yes, there always were. In fact, to give credit to this government, they built 4 fast-track long-term care homes on hospital lands within about a year and a half in the last couple of years. You know, that was impressive, but there are all kinds of hospital lands. There's all kinds of municipal land in Ontario. If they wanted to build long-term care homes over the summer and get them started, they could have gotten them started. We could be months into that. If they wanted to increase hospital capacity by bringing back staff who have retired out, who are burnt out, by paying their licensing fees, for example, by giving guaranteed work hours so they have some control over their schedules and so on, dealing with the staffing crisis in the hospital. They could have done that, even withdrawing Bill 124. They have refused to do any of those measures that all of us have called for repeatedly. If they had wanted to do a massive staff recruitment, like Quebec did after the first wave of the pandemic, to bring staff in to mitigate the crisis, they could have done that, and they have refused to do that. So it isn't that there aren't other solutions, there are, and this government has not done them. So I'm going to now turn it over to our co-applicants, the Advocacy Centre for the Elderly, who are bringing this case together with us. This is Graham Webb. He is the Executive Director of the Advocacy Centre for the Elderly and also a lawyer.
Good morning. Bill 7 is designed to do one thing: to bully and intimidate older adults to leave hospital for long-term care homes they did not choose and would not choose. I would like to look at this law through the eyes of the clients of the Advocacy Centre for the Elderly, a legal clinic that serves low-income seniors. This law will tear people apart. Older couples who have never been apart for 50 or 60 years or more will find one spouse in long-term care up to 70 or 150 kilometers or more away from home. Some will be separated for the first time in their married lives. I think of one of our clients in a rural community whose wife was admitted to long-term care after 65 years of marriage. He visited her not just every day, but twice, 3 times, sometimes 4 times a day, morning, noon, and night. He was there to help her with her meals, to provide care, to keep her company, and at times to kiss her before she went to sleep at night. If that woman had been admitted to a home up to 70 or 150 kilometers or more away from their home, her husband, who did not own or operate a motor vehicle and did not have the means to purchase transportation, would have had a great difficulty seeing her frequently or at all. These are often life sentences. The waiting lists for long-term care are such that our client's wife might never be transferred from a home she would not want to a home of her choice. Many long-term care residents will die in an unwanted home before they reach a home of their choice. Under Ontario law, as it is today, our client and his wife could have been separated for the first time in over 65 years, unable to see each other because of Ontario government policy, and to live the rest of their lives separate and apart, lonely, isolated, and alone. This law cannot stand. Although the government will gladly pay your transportation to occupy the first available bed in a home you didn't choose and never wanted, it won't pay your transportation to come home. If you lack the means to come home for Christmas, Easter, or Thanksgiving, then that's too bad. You're on your own. If your family, friends, and neighbors don't have the means to travel to whatever destination the government has chosen for you, then you will not have visits from your family, friends, and neighbors, and once again, you will be on your own. Some people will be traumatized by the non-consensual disclosure of their personal health information. Older adults who are victims of violence, survivors of abuse, Indigenous persons who attended residential schools, older adults who have suffered lifelong repression and discrimination over sexual identity and orientation, and others who have a deep-seated and legitimate mistrust of authority will be re-victimized by the inherent loss of power and control over their own lives caused by the non-consensual disclosure of their personal health information, as well as their non-consensual admission to a long-term care home they didn't want, and by the way, to a home that also might not want them. This law cannot solve the hospital bed crisis. It can only breed misery upon misery. There must be more options than just hospital or long-term care. The government has made the hospital the focal point, where in order to gain access to long-term care, now you must almost go to hospital first to have enough priority to get any long-term care bed. There should be other places to go as well, including community-based care aside from hospitals and long-term care. Thank you.
Thank you, Graham. And I'd like to introduce you to Ben Piper. Ben is our co-counsel from Goldblatt Partners, LLP.
Thank you. As Natalie mentioned, we're counsel on this application. So the Ontario Healthcare Coalition and ACE have explained really the basis of the egregious deprivations that are at play here. So I'm going to discuss a little bit of the legal framework and how we're going to approach it. So the challenge will be launched as an application to the Superior Court of Justice, where we will ask the court to declare Bill 7 as violating the Charter of Rights and Freedoms, and we'll ask the court to strike that law down, or at least the operative portions of it. We'll be bringing the challenge under two sections of the Charter. So Section 7 of the Charter protects the fundamental right to life, liberty, and security of person. We believe the bill actually violates all three of these rights in a number of different respects. As you've heard, it explicitly removes the right of ALC, alternative level of care, patients to informed medical consent when being assessed for and approved for admission to a long-term care home. These are homes that they would not have applied to, but they're homes that have vacant beds, and the bill just explicitly authorizes overruling informed consent through that assessment process. They are the only group of patients in Ontario, as a group, that is denied informed consent to medical procedures. That is an egregious violation. Bill 7 will not allow hospitals to physically move those patients, but, as you've heard, it coerces them with the threat of a $400 a day penalty if they deny or if they do not accept a transfer to a long-term care home that they have not chosen. That coercion happens at every stage of the process. So while they're only faced with the $400 penalty at the final stage, we expect that many of these ALC patients will acquiesce much earlier in the process, will see the writing on the wall, and will simply accept the fate that's chosen for them. Bill 7, as you've heard, allows patients to be placed far from their homes, from their families, and from their supports. This is particularly true for patients in Northern Ontario who can be moved anywhere in Ontario that has a vacant bed. During the process, Bill 7, again, explicitly exempts them from the protections for the privacy of their health information that are given to every other patient in Ontario. and instead authorizes a broad range of medical staff to access their health information without their consent to assess them and apply to long-term care homes on their behalf. And we know the harms that the dehumanizing nature of this process and the placement of ALC patients in substandard LTC homes and substandard long-term care homes can have. We've seen it during the COVID pandemic, where that different standard of care between different homes was laid bare, and where we saw the devastating impact of the separation from spouses, from families, and supports can have. Simply put, we think it's quite overwhelming that Bill 7 will take away decision-making by long-term care home patients or alternative level of care patients or their substitute decision makers on a number of fundamental personal choices that go to the basic heart of human dignity. That's a violation of the right to liberty under Section 7 of the Charter. It will equally result in significant psychological and physical harm to these patients, and for some, likely result in premature death, very likely. Again, that violates the rights to security of person and the right to life under Section 7 of the Charter. These are significant deprivations. We'll also be arguing that Bill 7 violates the right of these patients, of ALC patients, to be free from discriminatory treatment on the basis of age under Section 15 of the Charter. So ALC patients are overwhelmingly elderly, and this is usually the cause of their physical and mental health issues that require chronic care in the first place. The prejudice and stereotyping that they regularly face already is a big core of why we see Bill 7 in the first place and why they're being singled out for such exceptional and devastating treatment. Sections 15 of the Charter does not allow a government to enact a law that has a clearly disproportionate impact on a historically disadvantaged and stereotyped group like elderly patients. That's exactly what Bill 7 does, and that's why we believe it would violate quite clearly Section 15 of the Charter. So on those bases, we're quite confident that a court will strike down the law under both Section 7 and Section 15 of the Charter.
Thanks. Okay, so just to conclude, we're talking about elderly people here who are in the last months of their lives. The average longevity, the average length of life for people when they're transferred to long-term care homes is about 18 months to 2 years. These are people who will likely never make it back to a long-term care home of their choosing. It's a place where they will die. If it's far away, they'll die away from their families, as Graham described. There is no level on which this is right. We feel that we have to challenge this on principle. So with that, any questions?
Have you heard of any, we heard a lot of warnings when Bill 7, before it was passed, about people being forced. So are you getting any examples of people who've been moved? And can you give us, any lowdown on that? Any details?
Yeah, we have heard already and ACE has too, from people who have been threatened with $400 a day. Ever since they brought in the legislation in August, people have already started to tell patients that they are going to have to move or they are going to face this penalty. It has been a problem already that people were moved. What's new in this legislation is that they were coerced, What's new in this legislation is that they can do all of this without their consent, move them to a place without their consent that is huge distances away. So that has happened, and it is happening right now, yeah. And we actually asked by email and Facebook, and I'm just looking at our staff because we need to actually go through and make sure we have some people available for media from those lists, from people who've gotten back to us.
And I'm also wondering, do you have a number of people who've been moved so far, kind of against their will?
Well, no, and I think this is the problem. One, like Ben said, from the very beginning of the process, people are going to be threatened with a $400 fine. So they're going to acquiesce fairly early on, even though it's a place that they're afraid to go to or, don't want to go to, either because it's far away or because it has a terrible reputation for substandard care. They'll have to acquiesce. I mean, people won't be able to afford the $400.
Yeah, the only thing I'd add to that is realize that acquiesced consent is not consent normally. So what the bill does is it exempts these patients from the normal obligations to get informed consent from a patient before medical treatment is administered. because that would never pass any kind of recognition of normal consent.
Do you have any kind of court date for this to be heard yet?
No, I mean, do you want to answer that now?
No, but I think you were talking about if we push it, we're gonna try and move it forward so it's heard within the year, right? That's what we're.
I mean, I think it's hard to predict court deadlines. Typically, we're going to file certainly as soon as possible. So the regulations have just been launched today, so we're assembling that and we'll file very shortly. But no, we have not filed in court yet, but we'll be doing that very shortly. After that, there's typically you'll have some kind of case conference with the court to determine what the government needs to assemble this evidence, and that'll determine the court hearing schedule. But certainly we'll be pushing for it to move as quickly as possible.
Is the $400 the day the kind of the key, like because the law came into effect 2 months ago, but you waited till now to file the challenge? Like, is it?
Yeah. Well, the reason is that September the 21st, they actually passed the law really fast, right? It was passed in August. It was passed extremely quickly, no public hearings, and then they brought in the regulations. They introduced the regulations September the 14th, as I recall. The regulations came into effect September the 21st, so again, extremely quickly. And the first set of regulations was the overriding of consent that started September 21st, and then November 20th is the $400 a day. We had to get a legal opinion. We had to go through our boards. We had to figure out how we were going to raise the money, et cetera. So it's taken us till now to be in a position where we're going ahead, no matter what, we're going ahead with this unless the government withdraws the legislation and those offending principles, and acquiesces that this is really wrong, fundamental violation of their rights.
So just following up on Rob's question, between that sort of September 21st and today, have you heard of anybody who's been moved against their will? Yes.
Well, coerced, like, they in the end they have to acquiesce. They can't, tie them up and take them out.
Do you have a number, like how?
We don't have a number. We just have the people that have contacted us and the people that we've put out a call for people to contact us. There is no, I don't know who's tracking, like possibly the Ontario Hospital Association might be tracking, or hospital by hospital, or possibly the ministry.
As far as you know, this is not very prevalent.
Well, there are 18, by the last public number put out by the government, as you know, there were 1,800 patients who are potentially in this position, 1,800 people waiting for long-term care home beds in hospitals. So any number of those could have this happen to them. So, it's a significant number. And of course, once those beds are empty, more fill up, right? And then those people are subject to that same provision. So we're talking thousands of people, ultimately, for sure.
So now that there's a consistent fine, do you fear that these transfers are going to pick up? Is that the concern?
Well, under the regulation, they're required to fine people the $400 a day, so they're required to levy that.
But there were fines that could have been levied before. This just makes it $400 in hospitals.
I'm sorry, I didn't hear the question.
I'm just saying that fines could have been levied before for patients who didn't want to leave hospital, deemed ALC patients. So this is making it consistent $400.
I think you're asking, is there were fines levied before this legislation?
Right. And so
Well, they aren't actually fines. They're bed charges for uninsured hospital beds. And in our opinion, at the Advocacy Center for the Elderly, those charges are largely unenforceable, but we're not aware of any authoritative court decisions answering that question. And so what has been happening is older adults have been coerced, and they continue to be coerced into taking beds not of their choice. Previously, before today, they could have challenged in court the uninsured hospital charges. As of yesterday, the hospitals have a statutory right, in fact a duty, to charge $400 a day, which is a coercive charge beyond the means of most middle-income Ontarians. And so our concern is in large part that most older adults in hospital don't know their legal rights. They will be told this is what you have to do, and they will simply comply with what they're told they have to do because they feel they have no alternative. And the result will be that older adults will be accepting the first available bed, even though that bed is not suitable to their care needs, even though the bed may be in a home that is substandard, that had huge problems during the pandemic, that was occupied, it was helped by the military, even though the bed may be unduly far from home and prevent them from having visitors from their loved ones, their family, their friends, and their neighbors. And so without the actual forced admission, the threat of the forced admission is strong enough to wreak devastating adults on our clientele, the older adults who occupy hospital beds waiting for admission to long-term care.
And, oh, sorry.
Oh, I was just going to say one thing that I think is critically different between this and any prior regime is that if you were to go and tell a patient prior to the enactment of this law that if you don't accept this medical treatment, we will fine you $400, that would be manifestly invalid consent. That there's no way that would be viewed as valid consent. This law removes that requirement. You don't have to get any kind of valid consent. You are allowed, as a hospital, as a healthcare provider, to go and coerce a patient with the threat of a fine to accept the medical treatment. That's the fundamental difference that Bill 7 brings in.
The other difference, sorry, is that on the ground, like if people phone us all the time, have for years, for being pressured out of hospital into a place that's inappropriate. If we would intervene, the hospital would back down, and same with the Advocacy Center for the Elderly. Here now they have the legal authority. They have a requirement to charge $400 a day. They can override the 5, normally you choose 5 places, and the hospital would allow you to wait for one of those 5 places to come up. That's all gone now. Sorry.
A little clarification. So there's mention of the statutory requirement to charge $400 a day, but Benjamin is also saying the law allows hospitals to do this. So do hospitals have to charge $400 a day? Like, will it automatically
No, sorry.
start?
Yeah, to be clear, so the regulation requires hospitals to charge $400 a day. What the bill allows is for you to use that threat of $400 a day to get the patient's consent to go to the long-term care home or at any other stage. There's a provision of the bill that says normal informed consent procedures do not apply to these procedures, to these patients.
Totally clear, the hospitals don't have to do this.
Don't have to, they have to charge someone $400 a day if they don't accept a transfer to a long-term care facility. But it's true, do they have to, does the bill force them to identify patients? Not actively, no, it does not. It does not say hospitals have to do that. It
just
allows
gives
them
them
to.
that
It gives them that power to coerce someone with a $400 fine, yes.
And may I say, this law will disproportionately affect older middle-income Ontarians, older adults who own a home, who have an RRSP or a RIF or some small amount of retirement savings, whether it's $10,000 or $500,000. Those are the people who, when faced with a threat of a $400 per day hospital charge, if they refuse to go to where they've been designated to go, those are the ones who will see their life savings depleted, their homes put at risk, and loss of everything they have.
Peut-être juste entendre en français sur l'argumentaire que vous comptez de mettre de l'avant, particulièrement avec la section 15. Donc, ce serait une violation, une discrimination basée sur l'âge?
Oui, exactement. Donc, l'article 7, ça protège des violations du droit à la vie, la liberté et la sécurité de la personne. Et puis, l'article 15 de la Charte, ça protège contre, ou c'est une prohibition contre la discrimination en vertu de l'âge. Et vous voulez que j'élabore un peu sur l'argumentation? Donc, les violations de l'article 7 sont fondées sur le fait que les patients âgés, les patients qui peuvent être transférés à une maison de soins de longue durée n'ont plus de droit d'avoir leur consentement informé à une procédure médicale. Ils peuvent être transférés à une maison de soins de longue durée qui est loin de leur maison, loin de leur support dans la communauté. Il leur permet d'avoir leur information privées, leurs informations de santé privées peuvent être partagées à n'importe quelle personne ou un grand nombre d'individus dans le système de santé. Et puis, évidemment, il y a des impacts sur leur santé mentale, sur leur santé physique, avec le fait qu'ils peuvent être transférés à des maisons de soins de longue durée qui peuvent avoir un record, une expérience qui est beaucoup plus moins fort que des autres. Sur la côté de discrimination, c'est le fait que c'est un groupe qui est évidemment qui est largement des patients qui sont âgés. Et c'est la raison qu'ils sont le sujet aux stéréotypes et à la discrimination en général. Et puis ici, ce qu'on voit, c'est que ce groupe spécifiquement perd leur droit au consentement informé aux procédures médicales et ils perdent leur droit à choisir vraiment où ils veulent habiter, où ils veulent recevoir leurs soins de santé.
Can I just ask a question on another note, if you don't mind? Is the Ontario Health Coalition supportive of masking recommendations?
Yes.
What do you think of Ontario's Chief Medical Officer of Health apparently not following his own advice?
I was horrified to see that. I mean, you would hope that, chief medical officers would model the behavior that we're asking other people to follow. It was sad.
But he now says it should be up to you to make that best judgment. Does that not make sense?
Well, given the state of the pediatric hospitals and the adult hospitals, I mean, the adult hospitals have fallen out of the news because the pediatric hospitals are in such, chaos in the emergency departments and the ICUs, but they are still in unprecedented crisis. It's, at what point do we say the crisis is beyond handling? In our view, the crisis is unprecedented. It is tearing through any remaining resilience of staff in the hospital system, and it is time for mandatory protections of masking in indoor spaces, absolutely.
Would the Ontario Health Coalition like to see Dr. Moore resign his position?
We haven't talked about that as a board. When I have to just say, when I saw that video, I thought, whoa, he has to resign. I mean, yeah, it is not what we would expect of a chief medical officer of health in this circumstance at all. But I mean, we're not being splashy about it. We don't do that. We don't sort of, we're not asking for headlines calling for Dr. Moore's resignation. If he were to, act as though that was the wrong thing to do and, model behavior better for people or what have you, obviously he should, we'd want to give him another chance. We don't do that. We don't play politics in that way, But when I saw it, I thought, well, yeah, he should resign or something major should happen as a result of this.
Question for Ben. So the government tells us that there are other provinces that have similar policies in place that they've had for decades, and these policies are still in place. So how confident are you that a charter challenge will actually be successful, or are you hoping for a different outcome through a different means through? Well,
I'm not aware of any charter challenges to other provinces, and personally I'm not aware of the regime in other provinces. I think I'd say there are some quite significant features of this regime in its explicit overruling of the laws around informed consent and protection of personal privacy that apply to every other patient in the province. Even if there's some regime in other provinces that they feel is comparable, to me that is a quite notable feature. Informed consent already is quite established in charter jurisprudence right up to the Supreme Court as being a protected component of your right to liberty under Section 7 of the Charter. You have a right to decide if you consent to medical procedures. That's basic. And so overruling that explicitly with respect to these vulnerable patients, we think is quite striking. And similarly, the fact that it's such a clear age-delineated group that is being targeted for being carved out of the existing legal protections for consent and for protection of privacy, we think is quite striking.
And when you look at how this could proceed, is a partial win possible, that they get rid of some little elements but some parts go ahead? How could that sort of proceed?
Certainly that's possible in lots of cases. It's difficult to see here, frankly, because I think overruling informed consent in particular is quite core to the way this regime operates. The only way you're able to effectively, I mean, look, the problem they're trying to address for the government, they think, is that people are not moving quickly enough to long-term care homes. And so the way they've decided to fix that problem is to not require them to consent and to give a very effective bludgeon of a $400 a day fine as a way to achieve their consent, to coerce their consent. So, it's hard to see how you find a less, a less severe alternative to that regime. Yeah.
May I add that it's no defense at all to say that other provinces have been violating the charter rights of life, liberty, and security of the person and discrimination for older adults in other provinces for a very long time. If that were the case, then it would only add to the urgency for the court to intervene in this case, to uphold the principles and set down on the charter.
If that were the case, but sorry to add in, but Ontario has the fewest hospital beds of any province. Like, we're in a different realm compared to the provinces to our east, outside of Quebec. And we also have a low level of long-term care beds relatively. So like this particular crisis, Ontario is actually a radical outlier, has downsized its hospitals beyond any reason, beyond any evidence, beyond anyone else. It is quite a different context in this province, even if what they're saying were to be true, but they also, all the other provinces have different long-term care regimes, different definitions of long-term care. Like, I think it's very much a stretch to make that claim in the first place.
Would there be another way to free up beds, in your
Well,
opinion?
Yeah, we have, like, all across Ontario, we have entire hospitals that are shut down with all kinds of room. Beds are there. They're just pieces of furniture because they are not staffed in an operation. For years leading into the pandemic, like, if you look at Niagara, for example, there's the Welland Hospital, the Fort Erie Hospital, the Port Colborne Hospital, there's all kinds of, in London, St. Joe's, has been decommissioned largely, that hospital, all across the province that exists. So one, the physical structures are even there. But the issue is leading into the pandemic and in the first years of the Ford government, governments cut hospital funding below the rate of inflation. It was frozen for 10 years. Then it was run, below the rate of inflation. So real dollar cuts in order to force the downsizing of the hospitals. That was the plan. And so they were underfunded. We fund the hospitals at the lowest rate in Canada of any province by every measure. So, I mean, it is extreme. So one, fund them to open up those unused beds. Now we have a critical staffing crisis that has emerged, as we're in year 3 of the pandemic. And we've put, 2 pages of a list together for the province in consultation with all of the healthcare worker unions and health professionals and physicians that support public health care and so on. Literally 500,000 people that represent 500,000 people. And the government has done almost none of them. I mean, the bringing in of foreign trained workers, internationally trained workers, is a whole lot of PR without substance. It's a handful of people, 1,000 in the face of 50,000, 90,000 that we need. But all the other measures they have not done, and they are choosing not to do in order to maintain those budget targets, we believe. So yes, open the beds, deal with the staffing crisis, or at least do every measure that you can to deal with the staffing crisis, and build those fast-track long-term care beds. Like, the reason the long-term care beds are taking so long is they put them out to essentially to tender for the for-profits and not-for-profits and the public. They could just build the damn homes, build them publicly, build them now on the lands that we already have, and get them done and in operation. Could have been done all the way along.
I just have one last question. You mentioned earlier that someone who was forced into a home under this law that was in a COVID outbreak. Just wonder if you can provide more details on that.
Last time I looked, I think 150, I'll double check the numbers and give them to you if you'd like, but about 155 of the long-term care homes are in COVID outbreak. Then they changed the definition of outbreak, so as to make it a harder bar to reach, but because you now have to have multiple epi-linked cases. But there are a lot of long-term care homes in outbreak, and they changed the directives and the guidance multiple times. But over the summer, I think it was late summer. I'll have to double check the date. But so you can now admit people into, maybe it's the end of September, into long-term care homes that are in COVID outbreak. And so in this scenario, you would be able to coercively push people into long-term care homes that are in COVID outbreak, and it's not an unlikely scenario because so many of the homes are in COVID outbreaks.
So, but I thought you said earlier that you know of somebody who was forced into
Oh, no.
one of these homes.
Not in, well, I don't know,
Under
I'd have to
this-
check.
Under this law? No?
I'll need to check and see actually if the homes that they're being moved into are in COVID outbreak. I can look for you.
Can I just, Ben, you said that you anticipate filing very shortly. Is that today? Or what day would that be?
No, I mean, look, we can technically file by putting in a notice of application. We're looking to make sure we have some evidence assembled, but we expect to file, very shortly. I don't know if we want to, if we can say a specific day at this point, but we're actively kind of finalizing and developing that material.
Maybe.
What are we today? 21st. I don't know, Natalie. I think
By
we're certainly-
December for sure, yeah.
Yes,
that-
I think end of the month is a safe bet. We are very actively
Do you
developing.
need like a lead client?
Well, no, the clients are the two organizations here. But I think I would comment on, I think one of the things that's come up in a few of the questions is who are the people subject to this? And I think one important, I think Graham can probably speak better than I can to the particular group of patients subject, but I think it's important to recognize that when you have challenges like this, where the group being targeted is a particularly vulnerable group, it is one of the largest challenges is identifying, it's very difficult from our standpoint to say what are the number of people who are being coerced to acquiesce to give their consent to then go to a long-term care home that they would have never accepted otherwise. That's an extremely difficult thing to determine, and something we'd hope to challenge the government on very heavily in their own evidence is how many people are really subject to this. But I think Graham can comment better than I can on the people who are coming forward to ACE and to these groups. But these challenges, by their nature, most of the people affected are going to be hidden. They're the most vulnerable groups, and they're being coerced, and so most of them are going to be doing it quietly.
Exact numbers are not easy to come by because hospitals don't self-report publicly on how many people they've coerced into long-term care today, or this month, or this year. But we hear from those people constantly, and we are expecting to hear from many people who are being coerced into long-term care under Bill 7 and who will want to join this action.
I just wanted to tell you, we provided 4 things for you. They're there. One is the list of long-term care, just so, like in very real terms, the homes that have beds available are the ones that either no one wants to go to for good reason. They have hideous reputations and really bad reviews and so on, or they're far away. So just we put together a list of the 10 homes with the longest wait lists and the 10 homes with the shortest wait lists in each region of the province. You'll see that the military homes, the ones that the military went into, are on that list. That most of the ones that with the longest wait lists are the public and the not-for-profits. Most of the ones with the shortest wait lists where they might possibly be taking these emergency admissions are the for-profits with the really terrible reputations. We also gave you just a brief from the lawyers, the legal opinion, and a briefing note on fact checker on the government's claims about it, just in case that's useful. Please,
Okay,
is that
thank
it?
you.
Thank you very much.